counterfactual.
Thank you all for coming. Forgive the 5-year-old in the room. She's going to pay attention to and learned all about forced arbitration and the demise of class actions. First of all, please make sure that your phone is on silent. We might have folks going into a little bit of detox up here because we had to actually turn our phones off completely, and nobody does that anymore. If you need CLE, find one of the staffers in the room or somebody right outside of the room, and they will be able to help you. And at the end of the session, we are going to have time for questions and answers. We are taping the session, and so I'm going to ask you to make sure that you go to the microphone and take a turn there to make sure that we actually get your question recorded. With that, we're going to get underway. This is among the most profound shifts in our legal history. Ominously, business has a good chance of opting out of the legal system altogether and misbehaving without reproach. Judge William Young of the District of Massachusetts said that last year about the rise of forced arbitration in employment and consumer contracts of all sorts and the accompanying ban on class actions or any sort of collective response. Seemingly overnight, it's become nearly impossible to get a credit card or bank account, use a cell phone, purchase any sort of consumer good, apply for a new job, or even place a loved one in a nursing home without having to agree in advance that any disputes will be handled individually and through arbitration, a private, usually completely confidential dispute resolution system overseen by a paid decision maker and where the rules of civil procedure and evidence, and even federal and state law, do not apply. In the last 5 years, the Supreme Court has twice upheld forced arbitration and class action bans. The Federal Arbitration Act of 1925 that makes agreements to arbitrate, quote, valid, irrevocable, and enforceable. That act, according to the Supreme Court, trumps any interest in ensuring the prosecution of low-value claims, and thus preempts state law and other federal laws. Although some on our panel may disagree, the view from the left is that the Supreme Court chose businesses over consumers and wiped out the ability to address wrongdoing either alone or in combination. With the Seventh Amendment's right to trial by jury to some extent gutted by the Supreme Court, where are we? Has the sky fallen? Is arbitration working for consumers? Are class actions a better source of recovery and better means of holding wrongdoers accountable, or are they simply a means to line lawyers' pockets through no-injury class actions? Are cases even going to trial anymore? Is class arbitration an effective substitute, at least in some areas? We're going to try to cover all of this in the next 90 minutes. Easy peasy, right? I'm joined by a stellar lineup of thinkers, practitioners, and academics who will either solve everything or make it all muddier. So with that, Paul, the common criticism of class actions is that consumers get nothing and lawyers get rich. By contrast, arbitration would seem to address both of those criticisms by maybe taking the need for lawyers out of the equation and putting more in the pockets of injured or aggrieved consumers when they recover. Are these fair summaries, and why not?
You know, for years, the debate about was forced arbitration better, or was it better to have a legal system where the traditional legal system and having class actions laid over that was sort of an ideological debate where I think sort of people had, the consumer groups and the civil rights community and so forth were clearly on the side that you should still be able to have access to courts, and the sort of the business community and the chamber and the banks and so forth were on the side of no, arbitration is better, and it was something that people talked about as an abstraction. And so one of the things that's happened with the Consumer Financial Protection Bureau is that they've done a study where we now have an enormous body of empirical evidence that it shouldn't really be something that we're debating about in the abstract. This is getting more and more like, are cigarette smoking bad for children, and is climate change real? This is something where we're starting to get a lot of data. And the data is pretty clear. So under the Dodd-Frank Act, the Consumer Financial Protection Bureau, or CFPB, was charged with doing a study of is arbitration good for consumers or bad for consumers and interfering with the enforcement of consumer law. So they looked at every single case that had gone to arbitration on any individual in America brought to arbitration in front of the American Arbitration Association, which is by far the biggest of the consumer arbitration companies out there. And then they looked at more than 400 class actions and analyzed them. So the 400 class actions that they looked at, tens of millions of people got recoveries. The recoveries after attorney's fees, after all administrative costs, were $2.2 billion that was actually distributed to consumers. There were more than 100 class actions in which consumers just got checks or they got credits directly into their accounts. There were a bunch of cases involving debts that were illegal but past the statute of limitations or inflated or whatnot, where the debts were simply erased. And then there's also a lot of other injunctive relief that they weren't able to quantify very easily. So for example, I've been involved in a lot of cases where we've gotten people's credit records fixed, which can be extremely valuable to people. It can be worth a lot to them to fix their credit reports, but that's something that you can do in a class action in a large group of people. By contrast, the total number of individual cases involving consumers that went to arbitration over a period of 3 years was 411 cases per year on average over 3 years. Okay. So you had tens of millions of people in category A, and then you had 411 people in category B. As a lover of an anecdote, so I had 5 cases involving payday lending in North Carolina. So payday lending's legal in lots of states, it's regulated in some states, it's illegal in about 15 states. It's illegal in North Carolina. So we had 5 cases, we were in this rural part of the state, and we have one, this judge says, look, I can't handle 5 big class actions because the defense lawyers, there were so many lawyers on the other side of this case, it was unbelievable. So he says, well, we're going to divide these into 2 groups. And so the first, we're going to have 3 cases in the first group, and then we'll have 2 cases in the second group. So it used to be in America that there was this argument that was available to you in most states that if a ban on class actions that was in an arbitration clause could be proven to gut the consumer protection laws, essentially be like an exculpatory clause. It would be the same as if you had a contract that just said, oh, you can't bring claims under the Consumer Protection Act. If you could prove it was exculpatory, then a court would throw it out. Now, this all changed in April of 2011 when Justice Scalia wrote a decision called Concepcion, where he essentially said that all those state laws were wiped away. He overturned like 200 cases in like a moment. He didn't mention any of the cases he overturned except for one from California, which I still very resentment about because I'd actually argued the one case in California that they did mention that they overturned. But anyhow, in the Concepcion case, they just changed the whole landscape. So anyhow, so these cases, 3 cases go forward before Concepcion, and we got $45 million for the consumers in those cases, and we distributed checks to 200,000 people. We fixed their credit records. We wiped away illegal debts, and we got $45 million out. The other 2 cases came up after Concepcion. They were thrown out. The arbitration clauses were enforced. Nobody got anything. Okay, so it's really dramatic. And so one of the things that you're getting now in the debate about this is that the aggregate picture is really clear. So if a bank cheats or a payday lender cheats 100,000 people, a class action at least gives you the possibility that you can actually recover on behalf of all 100,000 people if you can meet the various difficult standards for class certification, that the cases are fairly identical, that they're all rising from the same sort of facts, that the case can be managed and so forth. You can get relief for all 100,000 people. If people have to go forward in arbitration, essentially every one of the consumers has to figure out that the law was broken with respect to them. So if they went to a payday lender and there's someone with a name tag and this place has a sign, the idea that the entire payday lending operation was illegal, like how many people in North Carolina actually knew that? Turns out pretty much nobody did. Basically people would come in and say they have a collections problem, then a legal aid lawyer would say, by the way, that's illegal in this state. And the consumer's always like, huh? So first you need someone to figure out that something was illegal. Then you have to have someone who's energetic enough that they're going to go and try and find a lawyer or go forward on their own. Then they have to figure out how to file an arbitration. So they have to go online and look at the American Arbitration Association's rules and figure out how to file a claim. Then if they do file a claim, then they have to actually go through and pursue it. And this is all over a couple $100. So essentially almost nobody does it. That's why you have, in the entire United States, 411 arbitrations in a year. So in a sense, this is really, it's a legal system. The individual arbitrations, you can talk in theory about, well, these are really fair, and consumers really like these and so forth, but almost nobody actually does it. 411 people out of hundreds of millions of people in America, all these different contracts that are covered, it's just a speck. And there's a law professor, Gene Sternlight, who came up with an analogy I really like for this. And what you frequently get from the chamber side is, well, look, from the individual perspective, how would people do if they went through an arbitration as opposed to if they went to court, and would they do better in an individual case? Since almost nobody brings cases, what Gene said, and I really like this analogy, is picture if somehow some sort of virus came from space and it killed 99% of the plants on the earth, right? So there's only 1% of the plants remaining. Essentially what the banks are saying is what we should do is we should look at the 1% of plants that are remaining and see if they're happier than plants that were here prior to the virus, but ignore the 99% of the cases of the plants that died, which are the cases that just disappeared. And obviously I think that that's a terrible idea. Are the cases all about lawyers? You know, the CFPB study found that about 15% on average of the cases, of the compensation cases went to attorney's fees. In our North Carolina case, in the first case, we got 30% as attorney fee, and in subsequent cases, the judge cut it to 25%. So the 15%, I think, is involving some really big cases. But it's certainly not that the cases are majority attorney's fees. There are some cases that are like that. I think that that's generally a bad thing. Although there are some cases in which what the case is really about is changing a practice and getting injunctive relief and fixing people's credit scores and those sorts of things. And those sorts of cases, it's harder to tell how much is for the consumers and for the attorneys. I mean, it can be ugly. And the CFPB study, by the way, was matched. There's a guy who used to be a clerk for Justice Scalia, Brian Fitzpatrick. He's a law professor who went out and studied over 100 class actions, went through and analyzed relief, and he found that average attorney's fees are under 20% as well. So this idea that class actions are all just about people like me who are like really greedy and we're just grabbing all the money and stuffing in our pockets and running off and then like throwing it up in the air and rolling around in it, sort of thing, that's I want to deny that as being what's really going on.
So Eric, why is Paul wrong? Is there a pro-consumer defense of arbitration and class action bans?
Thanks. So first, I've got to get out of my head the image of Paul throwing money around, which is not going to be easy. Yes, there is. I want to take a little time to try to reclaim arbitration for progressives everywhere, because I actually think that accepting as an article of faith that arbitration clauses are all a ripoff is a serious tactical mistake for those of us who care about giving value to consumers. Okay? And I'll do this in 3 easy steps. First of all, you have to recognize that class actions are, notwithstanding Paul's vigorous defense of them, they are an expensive way to deliver value to consumers. The actual CFPB figures, which I have in front of me, say that there was, during the period study, this is 4 years, there was $2 billion approximately in cash relief to consumers. And the attorney's fees and costs were $489 million. So that's not 15%. Indeed, depending on how you look at it, it's a quarter to a third, depending on how you play with the numbers. But I'm not going to quarrel about the numbers. I just want you to directionally understand that $500 million went to creating this $2 billion in recovery. But not just that $500 million. Let's assume for a second that the defendants are as expensive as the plaintiffs in these class action cases. So the defense of $489 of efforts by plaintiffs' counsel will probably cost somewhere around $489 million. So you're up to about $900 million for $1.5 or $1.6 billion in consumer relief. Well, then consider one other cost to this very expensive system. The Bureau's own findings found that 82% of actions filed as class actions yield nothing for the class. Nothing, not a dollar. So let's do some very rough math and assume that defending the 88% of class cases that don't yield a class settlement cost about as much as the 12% that do, right? That's got to be sort of right. That's another $900 million spent on this system of resolving disputes. So again, crude math, but directionally, we're paying about $1.8 billion for $1.5 billion in customer relief. So is that a good system? Well, it depends. You could fairly say, well, what's the alternative? There is an alternative, and it's one that's missing from, I think, Paul's analysis and from most of the analyses of this issue, which is that we have designed a better way of resolving consumer disputes relating to financial services. It's called the Consumer Financial Protection Bureau. Remember the numbers I just gave you a minute ago. In 2015, the CFPB, according to at least one report, returned $6 billion to consumers. $6 billion. The cost of the lawyers to do that, we don't really know. They don't break it out in the CFPB budget. But we know that the enforcement group is part of a larger group called Supervision, Enforcement, and Fair Lending. That group cost $140 million in all of 2015. So it's 4 times the recovery of the class actions the Bureau studied for about a third of the cost. Pretty striking, I think. And it makes sense that the Bureau would have built-in advantages on bringing cases like this. The Bureau has a fleet of lawyers. They have supervisors who spend time inside the banks demanding information. They have a world-class analytical staff. And they have the time and money to think strategically about what cases to bring to help the most consumers. In a world with the CFPB, I think it's very hard to argue that the CFPB isn't going to take out the best and biggest cases, the cases that most need bringing, the cases that consumers will benefit most from. And what will be left are the cases that are not so good, not so strong, maybe even wasteful of the money that is spent litigating them. So you might follow me this far and say, well, but wait a minute. I'm willing to take a chance that class actions will still generate value for consumers. And what do we have to lose? What you have to lose is arbitration. Now, it is certainly true, as Paul points out and will point out again, that, that not a lot of people are using arbitration. But we're here at the ACS. When was the last time you heard someone up here say, consumers are underutilizing a right they have, let's do away with it? Instead, it's incumbent on people who believe that arbitration works, which includes a lot of us, including myself, to try to help consumers access this vital source of justice. The arbitration is not perfect, to be sure, but if you're talking about what best to supplement the CFPB's ability to bring really big cases on behalf of lots of consumers, it's not another group of people to bring really big cases on behalf of lots of consumers. It's a system that addresses the needs of all the people who are left behind in the class action regime. And that's another thing we don't talk about nearly enough. We all know that it's hard to certify a class, right? There are a lot of people who have disputes that can't be certified as a class. The Bureau found that aside from the settlements, 2% of all class actions get certified as a class in this area, right? So most people, most claims by people are claims that aren't susceptible of class relief. And the class action plus CFPB regime offers them nowhere to turn, right? On the other hand, arbitration is a tool that, when used wisely, and frankly, perhaps used with the guidance of the CFPB, which has rulemaking authority in this area, could really help the people who can't bring a class action because of the type of their claim. There are already experiments with low or no fee arbitration, with plaintiff fees, attorney fee shifting, or double attorney's fees back if you prevail. AT&T has an arbitration clause that has a minimum recovery of $10,000, right? The AAA has a consumer due process protocol that addresses many of the issues that Paul has and will raise. And finally, we've only begun to tap the possibilities of online arbitration, which allow you to resolve disputes from the comfort of your home, something that class action surely will never deliver on. So for me, in a world where the CFPB is effective, doing its job, finding the big cases, bringing impact cases to change practices, what you need next is something that helps the individual consumer who can't find a class action lawyer, and that's arbitration, not more class actions.
Paul, I'll give you 2 minutes to respond on that one before we go on.
So the CFPB has been a really effective, well, I don't think anyone wants to hear a lengthy description of the numbers. I do think that Eric cut the numbers in several ways, which I myself would not endorse. I think you thinked around a little there. But the CFPB has been a really effective agency, there's no doubt. I mean, I think that it's done a great job. It can't do everything by itself. There are tons of cases that go into it, an enormous number of cases that go into it. They have, great enforcement lawyers. There are just not that many of them. There are a lot of cases that people, where people have been ripped off where they can't get relief from the CFPB, and the CFPB itself feels that way. Another thing is that the CFPB is really imperiled. So if you keep seeing House Republicans trying to zero it out, the idea that it's okay to wipe away people's ability to bring private lawsuits because the CFPB is doing a good job right now, is the CFPB going to be there next year? I mean, are we guaranteed to keep having a president who's going to veto, the efforts to wipe it out? The other thing is that administrations come and go. So you look at an agency like the Federal Trade Commission, so it was super effective in Obama's first 4 years when David Vladeck was running it. There were a lot of years in which this Federal Trade Commission was sort of this moldy, quiet place in which not that much was happening. So I think that the idea that you can sort of count on the government to fill in the gap and so that you don't need any private right of action if you've been cheated as a consumer is a troubling one.
So I want to shift stay in the class action realm. Paul, what about these kind of so-called no-injury class actions where, for example, there's a threat of a malfunction or a problem that hasn't yet materialized? I think the moldy washers is one of the big hallmarks of those cases, or statutory damages cases like the Spokio case that was before the Supreme Court. Do these kinds of class actions actually help anyone?
I first have to say that whoever it was who came up with the phrase "no injury class actions," that's like one of the best works of PR ever. I mean,
it's like mandatory arbitration.
Right.
Forced arbitration.
Right. It's brilliant framing. I think that the label is not very accurate. So for example, for a lot of statutory damages cases, there are a lot of things that are difficult to value. So how do you value privacy rights? What does it mean to someone to have someone infringe upon your privacy? How would you come in and testify to a judge? Oh, I felt really bad. I stayed up at night. I couldn't sleep. This sort of thing. I felt terrible about it, and so forth. It's a very amorphous sort of idea. So rather than having people have to go and try and prove it, what Congress has done for a variety of different statutes is say that you can get what are called statutory damages. So for example, under the Fair Credit Reporting Act, if an agency, a credit reporting agency, says something about you that's false, and they have really lousy procedures such that they should have had a better system so it's less likely to have been false, if you can put those two things together, then you can get $1,000 out of the credit the reporting agency, and you don't have to come in and testify of how it harmed you. Now, so does that mean, since you get an automatic sum, does that mean you weren't harmed at all, that there's a no injury there? I worked on a case where a credit reporting agency was going out and people would apply for a job, and they would the employers would go and hire this credit reporting agency, and they had two different products. So one was a 30-second super search, in which they would just tell you, or they give you something about someone's criminal record, or for $1,500 they could look for 30 days. So under the super search, what it turned out they would do was they just made an enormous number of mistakes. You had a name that was close to somebody else's name, they would mark you down as having committed a crime. If you had things, people had expungements, their things stayed on their record. And they just had a lot of things in which someone had, like if you had 6 of the same digits of your social security number as someone else. So it turned out there were 5,000 people who, if you compared it to their more detailed record, there were 5,000 people where employers had been told, yeah, this person is a rapist. This person is a meth addict or something like that. Okay, so the class action, we did not try and get each one of those people to come forward and testify separately about how they were harmed, because among other things you could never have done as a class action that way. So we sued for statutory damages. That's a perfect example of how you had to be a class action. Because one thing is that in general, what happened is most employers would never tell anybody, right, that, the reason we're not hiring you is because we did this search that says you're a meth addict. They just say, oh, we picked somebody else. Someone else got the job. And so the case was only found out about by accident. There was somebody who had something that was expunged when they were a teenager. They had a drug conviction. And a friend of theirs worked at the company and came back and said, they got you down as a crack addict. And the client was like, whoa, that's bad. And that was like the whole point of going and getting expunged right now that I'm in my 30s and, have been straight for a long time. And so this idea that these statutory claims have no value, I think, or that there's no injury there is wrong. The things about the moldy washing machines. So what you have here is you have products that in some portion of the case are going to have a defect and doesn't matter. So I think like a really good example would be this Taurus gun. So there's this type of gun made in Brazil, and it turns out if you drop the gun, they tend to fire. And it turns out that the better way to design a gun would be that if you drop it, it doesn't fire, right? And it turns out that it's really easy to do that, and that the vast majority of gun manufacturers design guns in which idiots drop the gun and it does not fire all the time. But these guns from Brazil fire reasonably often. So the argument of the no injury class actions, there's this bill in Congress, right? The House Republicans all passed this bill. It would say, any case that involves a product, you can only sue if the product's gone wrong. So you would have to, before you could sue and say, hey, you guys should do a recall of these guns and fix the trigger mechanism and get something else. And also, to the extent that consumers paid for a gun that they thought was going to be a reasonably working gun, that if they paid $1,000, I have no idea what guns cost, but in fact, they would have paid a lot less if they had known that the gun fired when dropped. That is, in fact, a species of injury, right? You paid more than you would have paid if you'd known what the product was actually worth. The idea that class action is wrong, and that instead what we need is a legal system in which you have to be shot first and then you can bring a lawsuit, that seems like a sort of crappy legal system to me. It doesn't make sense to me that you would say, oh, this is a no-injury case, because you have to wait till you've actually been shot before you have any legal rights. That seems like a completely backwards way of doing it.
Thank you. So Eric, a touted benefit of class actions and not of arbitration is the ability to affect real change on a company's business practices or behavior. Is there a way to do that through arbitration? Because the benefit through class actions, at least the view is, it's the sheer size of the action, the number of people that are involved, and the potential recovery that consumers might make, or the hit that the bank or the company is going to take to the pocketbook. How can consumers deal with that in arbitration, or is there a way to have that kind of change outside of the class action realm?
Yeah, so two answers. First of all, one of the helpful things that the Bureau did in its arbitration rule is require that people report arbitration results. And so if people bring arbitration and a trend starts to develop, either the Bureau will start paying attention and can look into whether larger scale enforcement action is required. But the biggest answer here is that in a world where you want institutional change, again, the CFPB in the consumer financial services area is so much more effective than class actions for a couple reasons. One is that the Bureau can monitor more easily whether a bank is following through on the promises it makes in a consent order, right? You might be able to figure out if a bank is complying from far away and bring it to the attention of a court, but the CFPB has supervisors and examiners in the bank who can ask for a document on a day's notice. And so if you want to be sure that your institutional change is taking root, you're much better off with a CFPB consent decree than with a class action settlement. At the same time, the Bureau focuses on these financial institutions. It's got real expertise. And so if you really want to change the system, right, then what you want is someone who understands the system. And with all due respect to the incredibly learned Paul Bland and his plaintiffs' class action brethren, the Bureau is really the expert on how financial institutions are put together and financial instruments are made and sold. And they're the best people to monitor on an ongoing basis if what you care about is injunctive relief and institutional reform.
There are a lot of questions I still want to ask, but we're going to turn to Suja. You've studied and written a great deal about juries and the diminishing role of the civil jury trial. What effect has the increase in forced arbitration had on the civil jury? And has there been a shift in who's making decisions in our civil justice system, and is that a good thing for consumers? A very small topic for you.
Right. So yes, over time there has been a shift in authority away from juries. The rise of arbitration is part of this larger trend that actually dates back to the 1930s, when authority that previously was given to juries in the Constitution started shifting to other bodies. And for a number of reasons, this is bad for consumers. So let me talk a little bit about the shift and why this is bad for consumers. So in the 30s, we saw the Supreme Court decide a number of cases that took away civil jury authority. So one example that I like to give is judgment notwithstanding the verdict, what we now know as judgment as a matter of law. I think most of you probably know that after a jury finds for a party, a judge can decide for the other party. And so this is judgment as a matter of law. Well, in the 30s, the Supreme Court said that is constitutional. But the interesting thing is that just 20 years earlier, the Supreme Court had actually said this was unconstitutional. And what had happened was the court had changed its mind, and previously it was only a new trial. So if there was an insufficiency of evidence issue, there could only be a new trial. And so this shift in authority that you see is part of this, what basically becomes a story about shifting authority away from juries to other bodies. And so this was one of just many cases where we see the court continue to change its mind to favor other decision-making bodies instead of juries. And so in this time period, we also see a shift of authority from juries to administrative bodies. And when this shift occurs, we actually see judges publicly stating that juries aren't as good as judges. So a quote or something that was said by Charles Evans Hughes in 1928, he said, "We are better, judges are better, and juries really should not be used." And so with this, and so Charles Evans Hughes had been on the Supreme Court and later was on the Supreme Court. And so he's saying this even though the Constitution gives juries authority. And so what we see then is with this publicly stating that judges are better than juries, they actually then shift authority to themselves. And so this trend away from juries continues into the 30s, beyond the 30s, and then we see, I'm going to shift to the 1980s for brevity's sake, but in the 80s we see, the summary judgment trilogy. And in the summary judgment trilogy, they start talking about how this is possibly constitutionally problematic, but this continues on. And then we see the arbitration decisions, and we see Gilmer, and then later on we see Circuit City favoring arbitration. I'm not going to go beyond that because most of you are familiar with all those other decisions that go thereafter. So all of this is substituting for jury authority. So the first point regarding one of the questions is basically what's happening with arbitration is part of this larger trend away from jury authority, where we have these other decision makers, judges and arbitrators, who weren't, in my opinion, intended by the Constitution to decide these cases. And then the second question was whether this shift is actually good for consumers. And the short answer is no, for a number of reasons. There are lots of statistics that plaintiffs lose more and receive less from them. Plaintiffs, for the most part, I actually haven't ever met a plaintiff's lawyer who wants an arbitration over being in court. Maybe there's someone out there, but for the most part, arbitration is not favored because it doesn't favor plaintiffs. And then arbitrators are deciding cases instead of juries, despite the fact that they're not better decision makers and may actually be worse decision makers. So there are a number of studies that talk about judges and how judges actually have some of the same characteristics as juries. So Chris Guthrie and some other co-authors have found that judges can't ignore inadmissible evidence. Judges are subject to unconscious bias. Judges do the same thing with respect to heuristics, things like anchoring, where there's irrelevant information and they tend towards that irrelevant information. So we know that judges have characteristics that are similar to juries. And so arbitrators have these same types of problems. And then in addition to that, arbitrators have other problems. They're drawn from the lawyer population, which isn't as reflective of the general population that we know. And then arbitrators also have biases that juries don't possess. We know that they're subject to reemployment. We know that they face repeat players. And then the screening of arbitrators, although in some systems it can be better than in others, that contrast, that screening mechanism contrasts to what we have for juries, which is where we know we use voir dire, and the parties really vigorously go after that. So I think all of this, what I've described, results in decision makers, which for the most part favor business, which I think is what we see in the statistics.
Right. So Suja and Paul, is the diminishing role of the civil jury trial generally playing out the same way in the class action realm? And we hear that class certification is kind of the death knell, or as we said, it essentially forces defendants to, blackmails them into having to settle a case that may not be meritorious just because the class has been certified, rather than take the risk of a loss at trial. Is that accurate, or are things changing in that realm?
The thing I would say is it does seem like there's been an uptick in the number of cases of class action cases that defendants are actually taking to trial. I've seen there was a case a couple of weeks ago in Baltimore where a debt buyer was operating on an unlicensed basis, and plaintiffs took it and the defendant would not settle at all, and the plaintiffs got a $38 million verdict. There was a big predatory lending case out of New Jersey last fall. The Tyson Foods case that was in the Supreme Court was based on a jury verdict. It was a wage and hour case in which people were being paid for 4 minutes of time when it took them 14 minutes to put on the various stuff that they had to do in order to work in this factory. And so there's been I haven't seen broad statistics, but I have a series of cases which I've seen recently which are going to trial, which I don't think would have been 10 years ago. And there certainly are not all plaintiffs' verdicts. I mean, the first washing machine case went to trial in Ohio, and the plaintiffs lost that case, and there have been at least 2 other cases I know of in the last 8 or 9 months in which defendants took cases to trial and won. But it does seem like, for whatever reason, that this idea that once you certify the class, the defendant's just going to suddenly open up the checkbook and say, "Oh my gosh, you've got us now. Here we're just going to start paying you." That's becoming less and less true, I think.
Yeah, and I wanted to add to that about this concept that basically cert equals then that there's blackmail settlements, and a lot's kind of been written about this, and a few comments. One, there's often a motion to dismiss prior to class cert, so there's been some merits inquiry before getting to class cert. And in fact, the famous Twombly case, which is not one of my favorite cases, but
Is it any plaintiff's favorite
right.
case?
But it was dismissed right before class cert. And then we all know that class cert itself, I think Eric might have even said this, that it's a rigorous process. And though it's not called a merits inquiry, often, unfortunately for plaintiffs' lawyers, does get into the merits a lot. And then we also have interlocutory appellate review that's available for class cert, not necessarily in every case, but it's possible. And I've also seen settlement rates that when you have settlements, you actually have settlements at the same rate in class actions as you do in other cases. So that doesn't indicate that there's blackmail going on. And then finally, I think there's really good business reasons sometimes to actually settle after class certification. I like to use the VW case as a good example because I actually have one of those TDIs. And then De Beers is often cited as another good example of settling for good business reasons. So I think there's enough in terms of checks in the process that what we have hasn't been proven that really there's blackmail settling going on after class cert.
I want to draw Kalpana into the discussion.
Hi there.
You have an experience that's unique, certainly among the panel and possibly in this room, in that you've actually done a class arbitration. Can you walk us through that and share kind of how it compares and contrasts to trying a class action case?
Yeah, I think this is a fascinating discussion, and I'll just say that as somebody who litigates class cases in the employment context, which we haven't talked a ton about yet, I must say, nobody is throwing checks at my clients. I haven't yet benefited from that blackmail settlement that my friends on the other side of the table like to mention. I have had an interesting and I think valuable experience in the last 8 or so years litigating in class arbitration in the Jock v. Sterling Jewelers case. It is a now certified class of more than 40,000 sales employees, women, who work for Sterling Jewelers stores across the country. And for those of you who don't know the company I'm talking about Kay Jewelers and Jared. I'm talking about this very big mall, mostly mall jewelry store company. So thousands and thousands of women. And we have litigated that case from federal court in the Southern District of New York into a AAA arbitration. We've litigated the question of clause construction. That is the arbitration agreement, does it permit the plaintiffs in this case to try to get a class certified? So we litigated that up to the Second Circuit. Cert was denied on that issue. Then we came back down and have litigated class certification, and we're now litigating that up. We're before the Second Circuit on that. We are litigating Equal Pay Act conditional certification, and we're litigating that up to the Second Circuit. I want to convey to you the sense that this process is difficult, and I think realizing the rights of these women in arbitration is not a straightforward matter, and so I want to disabuse anyone of the notion that this is an easy thing. It's not. And at this point, the team of folks that I'm working with, are litigating in arbitration, district court, and the Second Circuit all at the same time. This is not straightforward. I think it's worth, as Lauren mentioned, in the last few years, I think the discussion of class arbitration has focused a lot, sort of before this new wave of data in the CFPB study, we've talked a lot about the enforceability of arbitration agreements and class waiver provisions. And I think it's worth, and those take us to sort of the Concepcion issue and the American Express, Italian Colors issue of the effective vindication of your rights. I have a concern, which I'll just spend a couple minutes giving you some examples of, that I think what's happening in arbitration is that in small ways, that may not each rise to the level of a due process violation, say. In small ways, the ability of an employee or a consumer to vindicate his or her statutory rights is being slowly eroded or rapidly eroded in arbitration. And so I want to walk through some of the differences that I've experienced litigating in court versus in arbitration. Okay, so first off, I think Suja and Paul touched on a big one, the jury, right? No jury. And I think it's widely recognized that that really is to the disadvantage of the party who's seeking to sort of vindicate his or her rights. A second issue that I think doesn't maybe get talked about enough is confidentiality. Bilateral arbitrations between, one sophisticated business entity and another sophisticated business entity, those are presumptively confidential. However, class claims are different, and they should be different, because they implicate the rights of absent class members, and that's a big deal. And in fact, the AAA supplementary rules for class arbitrations recognize that. But I'll tell you that in reality, the arbitrator retains a great deal of discretion to decide what should be publicly available information and what shouldn't be publicly available information. And because the rights of absent class members may be implicated in those decisions, I think there's a really big problem with my having to, and I'm in the middle of it now, with my having to seek and seek again and seek again to have materials that, in this case, relate to class certification or the denial of class certification available to the public and to those people whose rights are being adjudicated. Transparency, although maybe it should be part of the mix in class arbitration, transparency becomes the subject of negotiation and motion practice. And I think relatedly, there's a question about what law applies in those negotiations. When you're in federal court and you are seeking to ensure that material is out in the public, open to the light of day, you have Federal Rule of Civil Procedure 26C. Now, does that apply in arbitration? It really depends. It depends on your arbitration. It depends on the rules that are part of that arbitration agreement. So not only are you litigating the question of whether that material should be public, you can sometimes be litigating the question of what rules govern that determination. Again, it's, I think, incredibly complicated. Another sort of concrete example I want to raise is discovery. I think a lot of people know that in arbitration, discovery can be much more limited. That is one of the hallmarks of arbitration. It's supposed to be speedy. It's supposed to be informal. It's supposed to be quick. And there's a variety of there's an interesting case law out there on the subject. In Gilmer, the Supreme Court made clear that explicit limitations on discovery do not invalidate an arbitration agreement. That is, they don't go so far. They may not go so far as to create a due process problem or a limitation on somebody's ability to vindicate their rights. But that's a fine line. And where does that line show up? Who draws that line? And where is it crossed? And I think that's a concern. The Fourth Circuit in the Hooters case, did call out a system for being too much of a sham, for having rules that were too much in the employer's favor. But again, that's another issue that needs to be litigated. And I think more often than the Fourth Circuit Hooters case, more often than not, employees and consumers have to play in a game with the rules written by their adversary. Rules that may be unfair in a lot of ways, none of which, however, may rise to the level of a due process violation. I think it's worth noting that one of my colleagues in the plaintiff's employment bar, Rick Seymour, did an interesting paper earlier this year about navigating discovery and evidence in arbitration, and he lays out a roadmap. You need a roadmap, and it's worth sort of understanding, again, those complexities. Related to this issue of discovery are limitations on compulsory process in arbitration. you use Rule 45 in federal court, and you can get third-party documents and third-party witnesses into an action. In arbitration, you have to look at the Federal Arbitration Act, Section 7, which creates all kinds of constraints and limitations on an arbitrator's ability to have testimony and documents compelled into the proceeding. And in fact, the arbitrator who is overseeing our case against Sterling Jewelers, Kathleen Roberts, who's a former magistrate judge in the Southern District of New York, wrote a really interesting paper in a sort of New York Bar Association journal about the challenges of working your way through the limitations created by FAA Section 7. All right, so that's a couple of different examples. Another, the scope of review on appeal. This goes both ways, I think. On the one hand, if you're in the AAA and under the AAA supplementary rules, there is an appeal of right at clause construction. There's appeal of right at class certification, and there's an appeal of right at the merit stage. Now, as I've just described to you, I'm 8 years or 9 years into a case, and our trial date is not for another 18 months, and that is because we have gone up and up and up again every time Sterling doesn't like the result. And they have a right to do that, right? The rules provide that. That's tough. That's even more sort of due process than we see in federal court, where Rule 23F says, all right, class certification, the appellate court can look at it if it wants to. Otherwise, you got to wait till the end. And I think that, anyway, it's Section 10 of the FAA that's worth looking at. This is the flip side of it. Section 10 of the FAA highly constrains the grounds over which an arbitrator's decision can be overturned. The arbitrator has an incredible amount of discretion to make decisions, and so you can wind up in a similar situation that we've wound up in, where we have what we think are well-reasoned decisions, 118 pages on class certification from the arbitrator, where she, develops the law, she understands the record, and ultimately, Judge Rakoff agreed with us, and we'll see what the Second Circuit says. But again, that's an appeal of right in arbitration, in class arbitration. Trying to just, I think the next point that I want to make goes a little bit to this idea that somehow arbitration is this excellent right that people should be taking advantage of.
Who would say a thing like
All
that?
due respect. Aside from a filing fee, when a plaintiff files a complaint in federal court, the administration of the federal court system is a publicly borne expense. It's a public good. That's not true for arbitration. And I point you to if you haven't read it, the New York Times 3-part series from last fall, which very prominently features our friend here. This friend. Really talks about what that expense can look like to actually try to vindicate your rights in arbitration. It can cost so much that it's not even worth it. Okay, a couple more points, and then I'll turn back to everybody else. This universe of the effective vindication of rights doctrine and Concepcion and Italian colors, and in the employment context, I think there's a related question of which was raised in the Chen Oster case, for those of you who know it, of what does it mean to have to be able to vindicate your rights, right? And I think the Italian colors case, an antitrust case, right? Proving your case requires $1 million in expert expenses, and it's just not worth it for an individual business to make that investment, and therefore doesn't bring the case. But that, under Italian colors, doesn't undermine one's ability to vindicate one's statutory rights. In the employment context, I want to just sort of note a reality that I think is particular to the employment context, which is that in a lot of cases where we seek systematic or systemic reform of an employment system, whether it's a compensation structure or a hiring structure or a promotion structure. We seek class-wide injunctive relief. That kind of relief, that kind of remedy is not available except where there's a class case. And so where you have a class waiver in the employment context, there's still a question of whether that does, in fact, effectively undermine one's ability to vindicate one's statutory rights. Okay, a couple of just really quick big picture points, and then I'll be done. I think that one of the things that wasn't said but was sort of touched on in Eric and Paul's discussion earlier is the value of the private attorney general's model. This idea that CFPB, or in the employment context, the EEOC, can somehow fill the space, identify the most important cases, and bring those cases, leaving the scraps to the private plaintiff's bar, the unworthy, unmeritorious cases. I just don't think that's borne out by the reality. I think there are, I practice in the employment space, so that's what I'll speak to. There are very important cases that don't get brought without private attorneys general to do that. And I think that model, that system, is a critical part of our statutory framework for vindicating these rights, and that can get lost. And I think that comes out in the new CFPB report, where I think 16 state attorneys general sort of raised that alarm, their fear that model is being undermined. Finally, I just want to reflect briefly on a more structural concern that I have that flows from the reality of practicing in class arbitration. My experience has been that I and my opposing counsel, we rely on federal law, we focus on state law, we cite cases from the Southern District of New York and the Second Circuit, just like you might do in a federal court case. But the reality is that there's no common law of arbitration. Arbitral awards are not precedential, and in fact, most are never made public. I have a real concern that as more and more cases, particularly employment and consumer cases, are shunted into mandatory arbitration, the body of law on which we all rely grows older and more stale. It doesn't reflect current employment practices, and I don't know how to value that in dollars and cents, but it strikes me as a very fundamental concern about the decline of the jury trial and the rise of arbitration.
Thank you, Kalpana. Eric, since you've been a good sport and playing the role of the punching bag here, I'm going to give you a couple of minutes to anything you want to respond there to what Kalpana brought up. In particular, this idea of what the question that we had posed earlier is class arbitration kind of an effective substitute for class actions, but also as she went to the effective vindication and the private attorney general model, anything in there in about 3 minutes that you want to respond to.
So I'll just respond briefly to a few things. First of all, my first impression was, boy, thank God I'm not defending that case, because Kalpana's so good at that, at presenting. Second was that it sounds like the arbitration forum, for all the problems we've identified, is you're making headway slowly but surely.
It can be done. It can be done.
It can be done. I was especially pleased to hear about how terrific the arbitrator's been in writing reasoned opinions based on the facts and the law. I was also struck by this notion of expense, which I think is a serious issue, but that's fixed a lot of ways that are simpler than getting rid of arbitration, right? You could have, and many arbitration clauses do, have fee-shifting provisions. The only other thing I think that would be most important for this group to know is that Suja has a book coming out in about 2 weeks, so if you found her comments as interesting as I did, it should be available on Amazon later this month.
There you go.
So everyone buy 2 copies.
All right, I'm gonna look to my timekeeper for help on this one. So we're gonna go down the row with this question. You'll each have 2 minutes, and you're gonna help me cut them off because I got no clock to make sure but I want to get everybody's input on this, and we'll just, Kalpana, we're gonna start with you and work down the row.
Great.
So there's a sense that the courts, including or at least the Supreme Court, is hostile to class actions and in favor of forced arbitration. And I'm guessing Congress isn't really going to do anything for a very long time. So what next? Is administrative agency rulemaking, like what the CFPB is doing, the next best option? Are we seeing movement by other agencies or in other realms? 2 minutes and go.
So again, just reflecting a little bit from experience here, and touching on a point that Eric just made, I do think that there is a way. It's a very narrow path through this morass to actually litigating a class arbitration, and you have to dance it carefully, but it can be done. I'd also say that I think we've had genuine success working closely with the EEOC and with DOJ. And I think that is obviously administration dependent. So I think that's an important point to make. But David Lopez and his program at the EEOC is tackling big issues and looking for systemic litigation. And I think the same can be said for DOJ. So I think that those are places to look. And I think we're not going to stop looking, speaking from the plaintiff side, we're not going to stop looking for the harms that are being done in the private employment context. We will continue to look for places that there are problems, and we will continue to try to push the law back in the direction that we think it should go. We've struggled before after the Dukes decision, and when everybody said class actions were dead, and they're not. It takes more work, and it's harder, but we'll get back.
All right, Eric?
So I think, though it's tempting to think as lawyers that everything revolves around us, that there's a lot of change that's going to involve not being in the courts or in arbitration. For example, Paul mentioned payday lending. Bringing cases, we could disagree about how effective or not that is, but the Bureau just released a payday rule that's going to just transform that sector. And so it's sort of an example of how there's more than one tool in the toolkit, and sometimes the right tool isn't anything that the likes of us do. To that end, I would say, really on all these issues, the most important determination of what progress we're going to make is on election day. And so, when you're done billing hours or bringing plaintiff side cases, spending some time making sure that the administration is one we can all live with is probably the best use of our time for the next few months.
Paul?
The administration, the administrative realm is actually where all the action is right now in the fight on forced arbitration and access to justice. So the CFPB has proposed a rule which would say that no lender subject to its jurisdiction can have, in any arbitration clause, can have a provision that bans class actions. I think that proposed rule is the most important pro-consumer development that we've seen since the Dodd-Frank Act itself was passed in 2010. It's enormously important. It will open up the courthouse doors in a way that's very, very significant. The Department of Education has begun to move against for-profit schools. There are a lot of for-profit schools that are really running scams, where they are essentially taking enormous student loans from people, and they're not actually delivering value, and you get a lot of people who, get pushed right out of, lower middle class into destitution, where they suddenly have tens of thousands of dollars of debt, and they haven't actually gotten anything that's going to help them go further. The Department of Education is going to say that they can't get student loans that are from government-sponsored entities if they have a forced arbitration clause that bans class actions. CMS, which is the agency that runs Medicare and Medicaid, is looking at a rule right now that would say that nursing homes can't get access to Medicare or Medicaid if they have an arbitration clause. If they pass that rule, that will enormously enhance access to justice for people who have, loved ones in nursing homes. The NLRB has said that the National Labor Relations Act passed back in 1935 has this provision that says workers have a right to concerted action, and that the idea that you can bring in a class action is a type of concerted activity, that's protected, and that employers who ban class actions and arbitration clauses are violating the NLRB, or NLRA back from 1935. So far, the case law on that is decidedly against my side. I'd say I think the most recent count is that there are 70 cases for the employers and 2 cases for the plaintiffs. But the most recent one was from the Seventh Circuit from a couple of weeks ago. It was a really good decision. And it just weirdly happened that the argument was like within a day of Justice Scalia's death. So maybe that law is about to change and become more open.
What I would say is I think I have mixed feelings about this question, because I think on the one hand we can have rulemaking that can be very beneficial, and the CFPB class action rule is an example of that. But on the other hand, if we have agencies involved in significant ways, and so for example, the CFPB deciding cases and awarding damages, or the SEC, which is another place where we see this, deciding cases and awarding damages. I go back to my broken record that, in fact, juries should be deciding these types of cases. So I think there's a role for agencies, but I think that if we over-agency the process, that we are going to get in trouble with the Seventh Amendment.
Okay. So I have 2 more questions for these 2, and then I'm coming to all of you, so I'm giving you warning that I'm going to expect a line there at the microphone in a few minutes. All right, so it's guessing game time. We have a vacancy on the Supreme Court. It might at some point be filled. Vice President seemed pretty optimistic about movement a little faster than I have been envisioning. But so, Paul, what's percolating in the lower courts that you think might have a better chance in a new Supreme Court than consumers have had in the last several years?
Well, I think that part of the reason that, so this NLRB thing that I just described, where the NLRB said in this case called D.R. Horton that a ban on class actions violates the National Labor Relations Act. A ton of the cases that went against the NLRB have very little description or explanation. I think there was just a sense of a lot of judges that if they ruled against arbitration, they were going to get overturned, because there were 5 members of the Supreme Court who just loved arbitration more than pretty much anything else in the world, and they were just always going to get overturned. And there have been all these cases that have gone up there that were losing by a 5-4 vote at least, right? So Justice Scalia gone, and suddenly the Seventh Circuit says, wait, actually the NLRB is right based on the language of the statute, based on the history. I think that that's an issue that I think if it goes up to the Supreme Court and Justice Scalia is replaced with someone who is more progressive than Justice Scalia, then I think that would be something that you could easily imagine going the other way. I think that it's going to be interesting to see what will happen with the Concepcion case. There are 2 justices in the court who've indicated very strongly they have enormous doubts about that. So when the Italian Colors case was decided, which was basically Concepcion applied to federal law, Justice Kagan called it a betrayal of the Arbitration Act's language about if people should be able to effectively vindicate their rights. She called it betrayal of the antitrust laws. That's very strong language. And then Justice Ginsburg was giving a speech a couple of weeks ago, and she described the Concepcion case and the Italian Colors cases as being similar to the Lochner era cases. Those are the old cases, right, where the Supreme Court was like striking down child labor laws and so forth, So I think that there is some hope that if Justice Scalia is again replaced by someone more progressive, you could actually see someone take a run at those 2 cases.
Thanks. All right, Suja, is there anything that the Supreme Court or the lower courts can do to help stop the decline in the diminishing civil jury trial?
So this is a tough question, because as I've described, the Supreme Court has over time really been not favorable towards the civil jury. So I think I need to kind of talk more about what I hope for as opposed to what can happen. I will say in defense of Justice Scalia, because I know that's not usually a popular thing to say at an ACS conference, but Justice Scalia had been very favorable towards the jury in many realms, including the civil jury as well as the criminal jury. And as a result, as someone who studies the jury and uses history to support jury authority, his death actually is not helpful towards moving jury authority. But I think that if I think about what I would say as to what I wish for, and I kind of argue for this in the book that Eric mentioned. I actually think we need to think about the jury as part of government. That we don't think of the jury as like the executive, or the legislature, or the judiciary, or the states, but the jury is exactly like those entities. it has authority in the Constitution. And even though we think about agencies as the fourth branch, I mean, there's no authority given to agencies in the Constitution, but there's authority given to juries. And so I argue that we really should think of the jury as a branch of government, and we need to start moving in that direction in order to restore the jury.
Thank you. All right. Questions? Come on up. Thank you.
All right. My name is Jay Forrester. I'm an attorney at Lee in Brazil in Dallas, Texas. I do wage and hour litigation on the plaintiff side. 2 comments. First, thank you all for coming here. In my world, on a day-to-day basis, this is really the most important conversation. So I appreciate that we're having it. And second, I want to respond to something that Suja mentioned. I wanted to out myself as the plaintiff's attorney that doesn't always like the jury trial. That's unique to a wage and hour case. A wage and hour case oftentimes I think is better suited for a bench trial, and we often don't demand a jury trial. I'm in Texas, and we have no equivalent state law that helps us, so we bring Rule 23 class actions in other states, but only FLSA collective actions in Texas, and I'm in the Fifth Circuit. So when there's an arbitration agreement in play, if it was just a decision of arbitration or district court, I know I'm going to lose, and I would just go to arbitration. But I just wanted to speak to what, for the FLSA, is the most important issue we're facing, which is the class killer clause. And we have so many clients that, for a variety of reasons, would not step forward but for the FLSA collective action mechanism, that when they're forced to an arbitration agreement and they have an arbitration agreement that they've unknowingly signed on their first day, they lose the chance to bring their claim. So I know we mentioned that a little bit at the end, but to the extent you can give me any hope or just speak to anything about that specific provision, because federal judges who are appointed by Democrats even just think arbitration agreements are infallible in Texas. So in my state, it seems like they're here to stay.
I think Paul's comments about sort of hope around Concepcion and Italian colors for those of us who practice in this world are maybe the best.
Well, I was going to say for
Back on that
Texas,
issue.
I think that the NLRB the NLRB decision, if that stands up, if the D.R. Horton decision were to become a rule of federal law, so that the National Labor Relations Act did not allow employers to ban class actions, then exactly, because I think if you just overturned Concepcion, I think the Texas Supreme Court would still uphold a class action ban. I think the Texas Supreme Court is actually to the right of where the U.S. Supreme Court was in Italian colors and so forth. So I think that you need an affirmative rule of federal law saying you can't do this, rather than what Concepcion would do is it would sort of take off the lid so that states could go back, the states that wanted to could protect that.
And we've done that some, but it's almost an irony that in Texas and district court, D.R. Horton, it doesn't do anything for you. You have to go to arbitration to begin with, where you're kind of giving legitimacy to that clause in the first place.
No, I'm speculating that things might change dramatically, but as of right now, the argument's not killing it in Texas, no doubt.
Hi, Chris Edmonds from Tulane Law. Thank you all for being here. It's a great panel. This question doesn't involve arbitration so much, but more about the use of MDLs. I don't know if y'all talked about that at all today, but it seems to me that that's a vehicle that benefits both the plaintiff side and the defense side. It's not as expensive, and you get to sort of do a few test cases and bellwether cases to see how it's going to go, and it encourages settlement in that regard. So I'm curious what your thoughts are on increasing the use of MDLs.
I'd say I think that there are a lot of cases where it's the only thing that makes sense. I mean, there's MDL involving a product that is very harmful to women's health. It's pending right now in West Virginia federal court. And if you're actually going to try every one of those cases, as great as juries are, if you're actually going to try every one of those cases, it would take like 20 years. So I think that if they are able to go through an MDL process and try, some sample of them, and then between that, the parties will figure out what they're worth and come out with something that makes sense. One thing where the MDL process, I think, has really got a problem is there really is a diversity issue in the MDL process. You have the vast majority of times that it's same couple of firms, but they're overwhelmingly overrepresented by sort of white guys running the MDLs. And I think that, I think if you took Elizabeth Cabraser out by herself, then all of a sudden the percentage of white guys would like double. So I think that that for the MDL process to start working better, I think you need people like Lauren and Calpania to start getting actually control of some of the cases. Otherwise, it does become sort of justice by white guy.
My name's Amanda Werner. I'm the arbitration campaign manager for Americans for Financial Reform and Public Citizen, doing a lot of work on the CFPB rule. My question is for Paul. So obviously the CFPB rule is facing a lot of attacks from Congress, from the Chamber of Commerce, from well-paid defense lawyers, things like that. How can folks in this room participate in the CFPB rulemaking process and make sure that the rule actually gets finalized?
So the rules have been formally put forward. There's a 90-day comment period. I strongly urge people to consider filing comments with the CFPB. They're accepting comments. I think they're going to become part of the record. The agency has to look at the comments and consider them before it can finalize a rule. If there are plaintiffs' lawyers in the crowd who have worked on consumer cases in the lending area, you've handled cases against a payday lender or a bank, where you handled a case as a class action that was successful, that you couldn't have gotten relief for your clients if it was an individual case, that would be a really important story and example for the CFPB to know, and the more details you can put in, the better. If you've had an experience of a client who went to arbitration and was treated really badly, that would be the kind of story that the CFPB would know. And so we really strongly urge people to make comments. We're going to be making comments. There's already more than 200 law professors who joined together and filed comments that were favorable to the rule, and it's a really important part of the system. So this is something that people can do.
Eric, did you want to add anything on that?
I invite everyone who's got an interest to file a comment. I think the process will be enriched.
You won't
by
take the
that.
bait.
Yeah.
Hi, my name is Cicely, and I'm a rising 2L from Harvard Law. So Paul, you mentioned Tyson Foods case, which was a highly anticipated class action case on using statistical evidence. But there are debate over how narrow the holding is and whether defendant side should embrace or fear the Tyson Foods decision. And I'm wondering you guys' take on how lower courts will apply the Tyson Foods decision in establishing class-wide liability. Thank you.
As an employment lawyer, do you want to?
Yeah, I think it's an open question. I think there's a lot of valuable potential material in the holding. We're looking at it very closely in terms of the question of whether we can apply it to determining damages on a formulaic basis in the employment context, determining back pay. But I think it can go either way, really. I think it's going to be heavily litigated, and I think there is a real interest on the part of the plaintiff's bar, whether it's the consumer bar or the employment bar, to make sure that we are talking to each other, to make sure that we are briefing together, that we are relying on each other, and not just sort of out there, because the formulation of law that comes out of it, I think is in some ways, it's open.
The one thing I want to say about the Tyson Foods case is the overreach in the petition was crazy from my perspective. So this is a case in which essentially, and particularly some of the amici who are on the side of the chamber in this case, they were arguing that you could never ever use statistical evidence of any sort in a class action, because that would be a trial by formula, which is a phrase that Justice Scalia had used in the Dukes versus Walmart's case and therefore wasn't allowable. And so, so the idea was that basically statistics are completely unreliable in this one area. So like doctors can use statistics in deciding what treatments are a good idea or not a good idea, and the military can use statistics in deciding how to build missiles or whatnot. But somehow statistics were, and you could also use statistics in an individual case to win an individual case. But if you use the field of statistics, at all in a class action was supposedly wrong. And I think that argument did not play well as it unfolded and worked out. And by the time it got to the court, you could not even find, even the Chief Justice was not really willing to defend that. And so I think that they ended up with a somewhat muddled decision. But I mean, I think that the upshot of it, I think, is really going to end up becoming fact-based more than anything else. I think that, in cases where we have what we think is good statistical proof, we need to have an expert who will be able to testify as to why the methodology was serious and valid, and we're going to have to be able to defend that expert against an attack particularly under the Daubert standard of what's reliable evidence. And I think that's going to turn out to be that there's very little doctrine, actual law in the case that's going to decide very much down the road. I think it's basically saying more or less if you have good factually based, scientifically sound or statistically sound models, then they can be used and they can succeed. And if you have models that aren't going to stand up, and so I think you see. Antitrust lawyers, antitrust claims all depend on statistical analysis as far as I can tell. It's like when I talk to antitrust lawyers, it's like talking to like a physicist or a mathematician. It's not like talking to a lawyer. And I think that those cases are all still going to turn on, who's right about statistics. I think that it's going to end up being what's true in the facts in the case.
I do think that Paul's point, I think it allows us to potentially, if we do our work well, allows us to maybe walk back over time some of the most damaging aspects of that part of the Dukes case if we do a good job. But as Paul says, I think it's really going to vary case by case. It's going to depend on the expert. It's going to depend on the lawyers. It's really, I think, relies on us to make sure we're putting forth sound expert analyses, that our regressions make sense, that we sort of can build a body of law back up around that.
All right. My question is aimed at you, Eric. I'm Michael Muti. I'm a litigator at Baker & Hostetler. I've litigated class actions on both sides of the V. These days, my practice is more like yours. Mm-hmm. And when you said you were going to give the progressive defense of arbitration, I got excited because I've never heard that before. And you did a good job. But one question I have, would your clients really believe that arbitration is a consumer-friendly type of device? Because I'm not sure that mine would. And if that's the case, why aren't we putting arbitration agreements that don't say you have to arbitrate, but we give consumers the option to arbitrate? That doesn't seem to be happening much, does it?
Yeah. So I think it's a very fair question. I think that businesses believe that arbitration is a good way to resolve disputes. I think they also think that in a world where they are subject to class actions and actions in court, right, enough's enough, right? So it is a reality, whether we would like it to be different or not, that the advent of the CFPB's rule is going to end the availability of arbitration in consumer contracts. And I think that's too bad. I think it is, we could all imagine a world in which businesses made available a whole array of options for them to be sued, but that's not a realistic goal. I think instead, we have to not look at arbitration as a Trojan horse when, in fact, and before it became a political punching bag, it was something that folks who were progressive really liked as a sort of humane-sized, efficient, effective way for an average citizen to be heard without the assistance of a lawyer. So again, I think there is a trade-off because financial institutions don't want to open 100 doors to being brought to a task. But it's too bad that we're shutting this one. I think it's the wrong one to shut.
Paul, did you want to add anything?
One thing that I think is an interesting idea is this idea that if you're in arbitration, you don't need a lawyer, because it's something that you hear a lot. And there are aspects of arbitration that are more informal. You don't have the evidence rules and so forth. But and certainly in the CFPB study of looking at arbitrations that had gone forward, the vast majority of people didn't have a lawyer. But I think that for a lot of types of cases, that if people don't have a lawyer, they're not going to be able to go forward. I think that there are some types of cases, like the cases I was handling against a payday lender, no one in the state was going to figure this out on their own. And I think that there are some circumstances where it's true that arbitration lets you go forward without a lawyer if you can figure it out. But I also think that even figuring out the rules. So for example, for the American Arbitration Association, they have commercial rules for certain larger cases. There are consumer rules for some smaller cases, but then there's a separate set of consumer rules for like claims against the wireless industry. There's a separate set of consumer rules for claims involving home construction, where you think it would be a consumer case and so forth. And then the rules can be pretty long, and there is an index at the beginning, but I find a lot of people can't figure out how they work. So I think that there's a sort of a, it's said as like a truism. Well, you don't need a lawyer in arbitration because it's simpler, and I think it's a lot messier than that. I think there are a few cases where that's true. I think there's a bunch of cases where it's not true, and so that is one thing I want to throw out about that.
Yeah, I think on that, the fact you really most often start with is you don't have a lawyer, right? Then the question is it easier to file a class action, file an individual action, or go online and find the relevant arbitration rules? I think it's the third of those. And the people without lawyers, that's almost everybody.
Hi, I'm Ben Langford. I'm from Montana. It's been a great panel, so thank you. Kind of speaking to some of the damage caps that have been placed on products liability and things like that, and how deterrence has always been one of the ideas behind class action and things like that. How do you think the move towards arbitration and how not much is disclosed and it's very kind of up to the arbitrator and it removes juries, as Suja mentioned, how do you think that affects on a broader scale the deterrence aspect of these suits against companies that are making shoddy products, and how they're able to, I guess in some ways you could say, enable themselves to do that more easily without the fear and deterrence of huge financial loss?
I'll just start. I'm not an expert on employment or on products liability, but I do know a few things about arbitration. I would say this, that the real deterrence in the area in which I practice, consumer financial services, is the government, right? And that's not going anywhere. Second, the CFPB rule, as I think I mentioned earlier, is making arbitration transparent, right, by requiring that people report awards. And indeed, I think there's a real opportunity here for someone public-spirited, to collect arbitration awards, to do draft pleadings for arbitrations, to put together a website that describes how to go through the arbitration process. And these are all very practical and relatively simple things that you could do to help the millions of people who don't have a claim that fits into a class action.
I would say that there are certain types of products cases that can't be brought as a class action that for various reasons, that it's either an individual case or nothing. The thing I would say that's important about those cases is that the facts about the cases need to come out. And so, for example, the first Takata airbag injuries, so this is this airbag that particularly in areas that have high temperatures and a lot of humidity, after a couple of years out, they sort of launch with a lot more energy than they're supposed to sometimes, and there are these swirling metal parts inside the airbag. So instead of being cushioned, there's a certain number of people who are essentially like being thrown into something that's not unlike a blender or something. It's really horrible. And so there have been more than a dozen deaths, and there have been like 100 really, really severe injuries with these airbags. The first bunch of cases that came out were settled on an individual basis, right? And then they were settled with confidentiality provisions and secrecy provisions. And so there was a long period of time there before there were enough cases that people discovered it. And so I think that for deterrence, that's in the court system. I think there needs to be a greater awareness, and my organization does a lot of litigating in the court secrecy area, challenging what we think are overly broad protective orders. But the arbitration system is designed to keep things like that confidential by and large. And I think that's a troubling thing to me about, I think that if you'd had if car dealers' arbitration clauses had existed like in 1990 and they had covered manufacturers, which they don't, for car dealers and manufacturers hate each other, so the car dealers have these arbitration clauses which they won't apply to manufacturers. But if you had arbitration clauses in that area, like all the Bridgestone, Firestone cases, we never would have discovered that. Because NHTSA hadn't put it together. It was only private litigation that brought that out. I do think that there are some types of cases that can be brought as a class action in the products area, and that there's no other way of dealing with them. And so, for example, there's no government agency that's allowed to do recalls of guns. So this class action against the Taurus gun, the gun that from Brazil that goes off when it's dropped, I think it's a really good class action. And I think that it's going to, basically it's going to get a whole bunch of these guns recalled. It's making the company stop selling a gun that shoots when it's dropped and this kind of thing. And I think the individual cases would never do that. So I think that that's an example of a place where I think it's a class action or nothing.
And I think the same themes apply in the employment setting as well.
Great. Well, we are just about at the end of our time. I want to give the panelists one last chance to, in a few seconds, if you've got anything else you want to add or something you wanted to cover that we didn't get to. Everybody's shaking their head, except for Paul. Yeah.
So the one thing so we were talking about, can you have a class action arbitration? There's one thing about this issue that drives me crazy, which is that the main argument as to why you can't have a class action arbitration is, well, you get a dingbat arbitrator who screws things up, and then there's no meaningful judicial review. So if you get a crappy arbitrator and they make a bad decision, then you don't have review, so it's not fair. So you should just never have a class action arbitration. And I got this argument from a justice in the California Supreme Court, and I'm really hoping that she was playing devil's advocate and is not going to vote against me, but I'm not super confident of that. But the thing about this argument is, in the civil rights area, when they were first talking about, well, can you have mandatory arbitration, pre-dispute binding arbitration for civil rights claims, there's the Leadership Conference of Civil Rights, the national, like all the major groups, the NAACP came in and said, well, you can't have arbitration of civil rights claims because what if you get a dingbat arbitrator and there's no meaningful judicial review? That's a crappy process, and civil rights claims are too important. And the Supreme Court's like, oh, no, that's, the crappy review is definitely enough. You don't need any more than that. And it was okay. And so there's sort of this goose versus gander idea of like, okay, so what you're saying is that like meaningless judicial review and the possibility of a crappy arbitrator doesn't matter for something like a civil rights case because the corporation wouldn't care much about that. But if it applied that to a class action, which a corporation would really care about, well, then we can't have it there, right? So it's like, so is this system good enough or not? So if it's good enough for civil rights cases, then it seems to me it should be good enough for class actions. And this sort of argument that it's that's fine in one area and not okay in the other feels really situationally convenient to me.
Paul, I also think that this sort of brewing or recently re-brewing question of who makes a decision about whether a class arbitration is permitted under an arbitration agreement, sort of whether this is a gateway issue, whether this is a threshold issue that's for the court or an issue for the arbitrator, I think touches on some of those same themes. And there's sort of some recent case law, the Del Webb Communities case from the Fourth Circuit, I think from a couple months ago, is the most recent one, saying that the court gets to decide that issue. And again, I think that it raises some of the same questions that Paul just raised about if one side of the V raises a set of concerns, it's good enough, and if the other side doesn't, it's not.
Yeah, I would just say, I think there is a special concern for absent class members in the class context that makes the role of the adjudicator different and may counsel for additional safeguards, no matter which side of the visa involved.
Great. So thank you all for participating today. Can we give them all a round of applause?